Hey everybody, it's week 7 and we're covering the judicial branch. Let's get going. All right, so here's the traditional what did we learn last week slides. What is the general structure of the legislative branch? Bicameralism, the House of Representatives, the Senate, 435 in the House of Representatives, 2-year terms, mini local districts, the Senate, 100 members, 6-year terms, acts as a voice of as a cooler to the voice of the people, while the House acts more so as the voice of the people. Remember, whenever a quiz may ask you what are some of the differences between the two bodies, make sure you emphasize the members and the term limits. We can also see that there are 4 steps in passing legislation in the U.S. These are: first, proposal by a member of Congress; second, committee. It gets debated and voted upon within a committee, and if it passes through a committee, vote on the House and Senate floor. The final version must be voted on both floors and get a majority vote by both bodies. And the fourth and final step is a vote by the president, either for approval or for veto. Describe the powers of the Speaker of the House. The Speaker of the House has the power to make appointments to numerous committees, refer bills to specific committees, is second in line to become the president right after the vice president, and has many other powers related to the actions of the House and interpreting the rules of the House floor. Describe congressional immunities. The representatives are immune from arrest while attending sessions and traveling to and from those sessions, but they're not safe from real crimes, treason or any significant felonies. They are not immune from violations of most laws at large. Necessary and proper clause. Necessary and proper clause establishes that the U.S. Congress can do whatever is necessary and proper to protect the security of the nation and its citizens, and acts as a constitutional legitimization for the expansion of legislative government powers, often sometimes utilized to act as a check against expanding executive powers. So we see necessary and proper clause is relating to the legislative branch and expansion of Congress's powers when necessary. Was one of the primary tools of obstruction used exclusively by the Senate? The filibuster. This is not in our Constitution, and the filibuster is a tool in which a senator is allowed to extend debate for an unlimited amount of time. The longest is 24 hours, and we've seen many individuals read things like every federal government documentation to green eggs and ham. What are some of the primary checks on the legislative branch? You see the judicial branch has the power to determine the constitutionality of legislative actions. And, it's a pretty general check on the other 2 branches. They determine the constitutionality. We also see that the executive branch has the power to veto legislation, sign treaties, and executive orders. We've seen a lot of executive orders in recent months and weeks, so those are some great examples of understanding what an executive order can do. And they can call special sessions in Congress. They can give speeches at the State of the Union. We're going to see Trump's first address to Congress. It's technically not the State of the Union, although it is basically the same format. We'll see that, and he'll set a public agenda through his speech. You'll see one of the powers exerted right there. And then how do we determine the number of electors in the Electoral College? Because remember, 270, that number we need to have a president win an election in the Electoral College. That is made up of total House representatives plus senators plus the lucky 3 in DC, because we need to give them some representation. So that's a little bit of review. Now let's keep going. So, learning objectives. Here are the general goals we have. We're looking at the judicial branch, so our federal court system. We're looking at the Supreme Court. We're looking at some landmark rulings that have been implemented in the last 50 or so years. And we're going to look at some checks that the other branches have on our judicial branch, as well as looking at the contemporary Supreme Court. So, you do not have to remember these numbers. The only number in this slide you have to remember is 3. We have a 3-tiered federal court system. This is provided in Article 3, Section 1 of our Constitution, in which we established the Supreme Court and then the lower courts to follow. So our 3-tiered Supreme Court system, our 3-tiered court system, not Supreme. I'm waking up today. So at the very top, the most powerful court in the United States is the Supreme Court. we only have 9 judges on the Supreme Court, and there was only one court at large. This is the highest court in the land, and their rulings are the final rulings. They provide significant landmark rulings on countless detailed issues. Some of it, I think 3 or 4, we're going to go into detail on today. We also see that a step below that, you must go through the lower courts to reach the Supreme Court. Also, below the Supreme Court is the circuit courts. These are courts in which you have panels of 3 judges at a time. 3 judges will work together to hear a single case. These cases, before they reach the circuit court, must go through a lower court. These lower courts, and there are many of them, are district courts. This is where the majority of federal judges reside. These are 1 judge per case. This is where you'll see trial courts. This is where you'll see the famous trials that you see on TV. They're occurring a lot of times in district court. So we see the 3-tiered system: district, circuit, panel of 3 judges, district, 1 judge, and then the Supreme Court, where you have 9 judges. So you see we're gradually adding judges, loosely speaking, to make sure we have more reliable rulings. Oversimplified purpose, but there you go. Here's a visualization of the last slide. As I said before, you have the U.S. District Courts. You have the Court of Appeals, also referred to as the Circuit Courts. That's where you have the 3-judge panels, and then the Supreme Court. You have to make it through these courts to make it to a Supreme Court ruling. You also have off branches of the U.S. tax courts, claims courts, international trade. If you get into law, that's a direction you'll look into studying in more detail. Today, we are not going to look at this beyond understanding a 3-tiered court system. So, what are the differences between some state and federal courts? Well, one of the most important differences is how the judges are appointed. For one, on the federal level, as we remember in the past lectures, the president appoints federal judges. Every one of the judges in that last graphic, the district, circuit, and supreme, the president has the authority and responsibility to appoint those individuals. You oftentimes see that these are nonpartisan appointments. These are the best judges for the job when possible. And we've seen many judge appointments. We're going to go into detail. We've talked about when we looked at the filibuster, the amount of times it was utilized during Barack Obama's administration on these federal judges. So we see there are hundreds of judges to be appointed, so you can't have significant delay on every single one. As we remember, there were a significant amount of, I think it was 68 or something, filibusters on federal judge appointments, which you can see can create significant problems in delaying government. And that could happen under any presidency, and it happens often. So we see federal judges are appointed by the president and then must be approved by the Senate, and that is where the filibuster power is available. Now, these federal judges interpret the law based off of, they interpret rulings based off federal law and the federal Constitution. So any written statutory law by Congress or the U.S. Constitution. They do not recite executive orders when providing their rulings, exclusively the Constitution and statutory law. Oftentimes, executive orders are what is in scrutiny. So we see just an example of checks and balances, not any specifically targeted point there. We also see on the state level, state level judges are appointed by the head of the executive on the state level, the governor, or there are multiple different avenues for, 2 different avenues for appointing judges on the state level. In the state of Montana, we have the opposite strategy. We don't allow the governor to appoint our judges. Instead, we appoint judges through nonpartisan elections, and many other states do this as well. You probably remember the slightly different campaign ads you saw a few months ago. Now, it is also important to remember that state judges rely on interpreting these state laws and, again, these state constitutions. We remember every state has their own constitution. Montana drafted theirs in the 1970s. We have one of the very few references to the citizens of the state having the right to free and clean environment, which is we've seen in a state court ruling being relied upon, as they ruled that in favor of, I don't remember the specific example, but I think it was Held versus Montana or Held versus something, and they ruled in favor of Held, in favor of the young individuals suing for their right to a clean environment. Just an example, you of course will not have to remember that. The key takeaway, the difference between state and federal, especially in who appoints the judges. Now, there are two different types of cases you will see in the federal court system and the state court system. These cases consist of civil and criminal. Civil is a minimal burden of proof. You won't have people being arrested for these crimes. Some examples consist of like breaches of contract, personal injury, property disputes. You have family law issues. You have, I think, a great example of the difference between criminal and civil and the burden of proof, and one that was publicized heavily, is you look back, rewind to the 90s, the OJ trials. We remember that OJ was found not guilty under a criminal trial, but was later brought back to court through a civil trial. And this shows how there is a minimal burden, a lower burden of proof, as he was tried guilty in the civil trial. And the outcomes were monetary damages and payouts to the families involved. So we see that criminal has a much higher burden of proof. Criminal is where you see people with results consisting of incarceration, fines, community service, probation. These are serious crimes. They sometimes consist of assault, theft, murder, many other crimes that you could think of on the federal or state level. So the primary difference between a civil and a criminal case is that there is a lower burden of proof in civil cases, and they often revolve around in a conflict between individuals, or an individual, a company, and individual or community, something along those lines. Now, we won't have to remember each of these amendments, but there are some aspects you will, and it's worth going over a quick review because they relate to your life. So the Fourth Amendment, this provides protections against unreasonable search and seizure, requires probable cause and a warrant. This was a big foundation pushing against the stop and frisk policies in New York City a few years ago, which was a significant piece of political debate. We also see the Fifth Amendment. If you've seen any old bits of comedy, I plead the Fifth. The Fifth is your right to due process, protection against double jeopardy, and self-incrimination. I plead the Fifth is referencing that last point, self-incrimination. You do not have to speak against yourself in court. You also, in the same amendment, are protected from being tried for the same crime twice, and you have a right to due process through our court system. Our Sixth Amendment addresses a fair and speedy trial, public trial, impartial jury, and a right to be informed of charges, right to confront witnesses, and a right to counsel. So starting from the back, going to the beginning. You have a right to counsel. You have a right to have an attorney present and not speak until you do so. You have a right to confront witnesses. No, you cannot yell in their face. No, you cannot smack them. Whatever you may be imagining, you have the right to have them, to confront them about the charges that they are bringing forward or about what they witnessed to a scene. You have the right to bring other questions to those witnesses to verify their account. You have, my cat's over there wheezing in the background. Sorry about that. Oh, my mush. Sorry for my cat. You also have the right to be informed of charges. You cannot be arrested without being informed of your charges. You see something, this is where you'll see Miranda rights, and you'll also see that people will frequently ask, what am I being charged for? Well, the police and our court system has a responsibility and a duty to notify the individual. You also have the right to a public trial with a jury of your peers, and it has to be relatively fast and accessible, fair and speedy trial. We cannot have you wait in jail for 3 years as we prepare a trial. We have to get this moving relatively quickly. The Seventh Amendment is a right to jury trial in federal cases. This is important regarding the distinction between civil and criminal cases, but the main takeaway from our Seventh Amendment is that you have a right to a jury trial in federal cases as well as state cases. Our Eighth Amendment protects against excessive bail, excessive fines, and that famous line, cruel and unusual punishment. It could be cruel or unusual if you have a originalist interpretation. But if you're a living constitutionalist, you may say cruel or unusual punishment is banished. And the living constitutionalist interpretation is what has won out over time. We'll go over that later on, a point we'll cover. Sorry. have to drink something because I'm talking constantly. All right. Eighth Amendment also protects against excessive bail and excessive fines. We can't have somebody who was arrested for stealing $1,000 worth of goods have to pay 100,000 to get out of jail. Good example. 14th Amendment. This amendment does a significant amount. Next week we'll be going into this amendment in detail, and we'll also give you that overarching impact from this amendment, which is that it granted citizenship to any individual born in the United States, as it was implemented during the Reconstruction era, as we were granting rights to formerly enslaved citizens. So in our 14th Amendment, we also expand due process protections and equal protections under the law. Incorporation doctrine, which we'll go into in detail later on, grants courts the power to review state laws, and you'll see a lot of protections provided to individuals through the implementation of the 14th Amendment. But again, we will go into excruciating detail on this amendment next week. So, judicial appointments. A little review here, but remember that presidents make judicial appointments in the circuit, district, circuit, and Supreme Courts. Senate Judiciary Committees must then debate the appointments. This is where you will see the hearings, where you'll have, we see them right now. One that you've probably seen on the news is RFK Jr. He's a name that most people are familiar with, and we've probably heard about that process. Although there have been committee debates and hearings for appointments over the last few weeks for many individuals. But RFK Jr. is a good example of one when they were asking him questions and he was answering them. That was an example of us seeing the actions of the Senate Judiciary Committee debating the appointment. And then when you turn on C-SPAN, you saw a bunch of people in that big room walking up and down to that front desk, casting their votes. That is them voting on the appointee. So they will then vote to see if RFK Jr. can maintain his cabinet appointment. And we also see that with judicial appointments, judges, Supreme Court justices. We do not have a Supreme Court justice being appointed now, but when we had Brett Kavanaugh, Amy Coney Barrett, and Neil Gorsuch, we also saw Ketanji Brown Jackson in recent years be appointed and have their judiciary committees be answered, and we saw them answering questions in front of the judiciary committees. But beyond this process of being appointed by the president, debated upon by the committees in the Senate, and then voted on by the Senate, we see that judicial appointments have, for one, lifelong appointments. They hold this post for the rest of their life or until they retire, and there are absolutely no qualifications, no required qualifications for being a judge or a Supreme Court justice. There are traditional qualifications that past presidents have relied upon. We won't go over it. Sometimes I used to cover what George Washington used as his requirements back in the day, but a little outdated, but also still maintained for a large part. But we see that almost every Supreme Court nomination has been a past judge, has been an individual with significant law experience. And we do see that when we look at our history, the very first Supreme Court justice ever appointed through this process was John Jay, one of the contributors to the Federalist Papers. In recent years, when we look at some presidents, we see that George W. Bush appointed 322 federal court judges, Bill Clinton appointed 367, Obama appointed 329, all of which were done in two-term presidencies. Trump appointed 226 in his one term in office. I do not have the number for Biden, as I have not recently researched that. But I would assume it is probably a little bit lower than Trump's 226, considering his one term in office. And our U.S. Supreme Court. So remember, the U.S. Supreme Court is the highest court in the land. We have a total of 9 Supreme Court justices that reside on this bench. We have 3 justices that have been appointed by Democratic presidents, 6 justices appointed by Republican presidents, and we have had a 9-member Supreme Court since 1869 with a little bit of ebb and flow here and there. In 1789, we established a 6-justice Supreme Court, our early Supreme Courts. We saw rather quickly, right around when we implemented the 12th Amendment, 1801, the number increased to 7 justices to have one to break ties. 1803, it was reduced back to 6. Why? I don't even know. 1819, we brought it to 7 once again. I would assume just to make sure we have consistency in breaking ties. And then in 1837, apologies, we increased the number to 9 justices for more perspective to be considered. We did have a brief period in 1863 when we had 10 justices. Why? I don't know. And then the number was permanently set to 9 in 1869, as it says down below, and it has remained there ever since. That's why considerations of stacking the courts have oftentimes been short-lived. All right, so we see that the Supreme Court hears about 80 cases a year. The Chief Justice of the Supreme Court has the influence and power to determine what cases will reach the Supreme Court. The Chief Justice is currently John Roberts, appointed by a Republican president, but represents the middle of the road of our Supreme Court quite well in recent years. We also know that our Supreme Court single-handedly does not have any enforcement powers. By that, it relies on the other branches of government to enforce their rulings. So we see that the judicial branch may rule something. I'm trying to think of a non-heated issue. May provide a ruling regarding the role of religion in government. And then it is the responsibility of the executive branch in the states to implement that ruling and make sure their laws are aligned with the ruling. Now, if the laws and actions of the states, executive and legislatures do not align with the judicial ruling, then we could see further court procedures, these scenarios making their way back to the Supreme Court. Now, I briefly mentioned this. Well, our textbook covers this. This is a consistently emphasized frame of understanding our Supreme Court in contemporary years. We do know that our contemporary Supreme Court has a conservative leaning. I am not here to place any opinions on that other than to point out that it exists. Now, the current Supreme Court do not represent party preferences. Our Supreme Court is distant from partisan politics. Those appointed by Republicans are not going to vote how the Republican presidents who appointed them would have exactly. They may have a leaning in favor, but more likely they are likely to align in their ideologies, conservative or liberal at times. So we see that the majority of our justices have a conservative leaning interpretation of our Constitution. This does not mirror Republican Party preferences. We see within well, I'm not going to go in detail on that, but we do see that our conservative courts have provided rulings in favor of protections of LGBTQ rights. We also see they have ruled in favor of Obamacare being protected constitutionally multiple times. So we see this is not a partisan body of government, but there are loose leanings at times, which we will cover in just a second. Actually, and right after this slide. So remember, requirements becoming a Supreme Court justice, there are none. Does not require a law degree and does not maintain an age requirement. Appointed by the president, lifelong appointments. Our Constitution says, quote, the judicial power of the United States shall be vested in one Supreme Court and such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall, as stated, times receive for their services a compensation which shall not be diminished during the continuance in office. Now, I'll go over this now. Some of the criteria used by George Washington as he appointed the first round of Supreme Court justices consisted of support and advocacy for the U.S. Constitution. Remember, the divide between Federalists and Anti-Federalists was fading out, in which there was debate over the validity of the Constitution. We also see distinguished service in the American Revolution. That's a unique one. It'd be hard to enforce nowadays. Active participation in the political life of a particular state or the nation as a whole, oftentimes through judicial experience and also prior judicial experience. And another one that is interesting, either a favorable reputation with his fellows or personally known to Washington himself, which is the reality of government, that you must be known to be considered. You must know George Washington himself or have a favorable reputation with people associated with George Washington. The honest reality of government, of all society, any appointments, any jobs, you got to know somebody on some level or be a very favorable candidate and have a favorable reputation. Okay, so briefly we talked about how Democratic presidents have appointed 3 Supreme Court justices, while Republican presidents have appointed 6, and we currently have a conservative leaning Supreme Court. Well, remember that our Supreme Court is a partisan body of government. We do not encourage, we actually discourage any partisan representation of politics in that body. So we see that they do not represent Democratic and Republican party positions clearly. We see that they better represent originalism and living constitutionalism. This is a better definition of defining divide among the Supreme Court than party partisanship. So when we look at these two terms, originalism means that you are taking the Constitution as it was written. You are considering what our founding fathers meant, and you are reading the text word for word. You would look at something that says cruel and unusual punishment. That cruel and unusual punishment is not allowed, but if you interpreted it directly as it was written, you could argue that cruel punishment is allowed as long as it is also not unusual. So, because they use the word and instead of the word or. So we also see the opposite side of the spectrum is the living constitutionalist. A living constitutionalist says constitutional law can and should evolve as generations and threats come and go. So we see that the living constitutionalist would say that cruel and unusual punishment, well, we know that both cruel and unusual punishment is absurd in the eyes of many citizens today, so we'll say you can't have cruel or unusual punishment, although you can't, although our Constitution uses the word or instead of the word or. Uses the word and instead of the word or. So when we look at an example of these different interpretations in effect, we see the District of Columbia versus Heller in 2008, which is a Supreme Court ruling. We'll go into detail a little bit later on in this same slide. It is relating to gun rights in Washington, D.C. So with that very simplified interpretation, we know that the originalist interpretation of Columbia versus Heller is that we are going to rely on the founding fathers' objective when they wrote the Second Amendment. And we ruled that we use this to interpret what they meant by a well-regulated militia. And this provided protections. This acted as the foundation for the ruling, which did win, that provided protections for gun ownership and personal self-defense in Washington, D.C. So we also see there was a dissent provided by a representative of the living constitutionalist perspective, Justice John Paul Stevens. And Stevens argued that he aligned with a more living constitutional approach and argued that the Second Amendment should be understood in the context of modern societal needs. He believed that the original purpose of the amendment was to ensure state militias could defend against federal overreach, not to protect an individual right to own firearms unrelated to military service. So even he pulled a little in originalism, as neither of these interpretations of our Constitution are hard-lined. Every one of our Supreme Court justices maintains a little bit of each approach, but they favor one over the other. So we see that regarding gun regulation or cruel and unusual punishment, we can see the difference between an originalist and a living constitutionalist. An originalist says our founding fathers wrote our Constitution this specific way. We have the Second Amendment that provides a well-regulated militia. We must not look further into it. The living constitutionalist says, yes, that is all true. Our founding fathers wrote this document in this way with this interpretation, but this is how the threat that they were addressing has evolved over time. And this is why we must either maintain that approach or shift how we approach addressing it. I personally believe neither of these approaches is correct when single-handedly relied upon. We must have a nuanced approach. That is my opinion. I also think if you disagree with me, you have all the right to disagree with me, and that will not impact your grade at all in this course. Originalism or living constitutionalist, it's a way to identify the way our Supreme Court justices interpret our Constitution and statutory law. Now let's look at our current Supreme Court. We have, as I've said ad nausea, 6 appointed by Republicans, 3 appointed by Democrats. 3 of these Supreme Court, 3 of the 6 are appointed by Donald Trump in recent years. That is not uncommon. We see recent presidents having significant appointment powers over the Supreme Court, with ebbs and flows, as some presidents, just because we have some healthy Supreme Court justices, do not get the opportunity to appoint justices during their tenure. Justices are intended to be nonpartisan and not foster specific ideologies, although that is not always the case, as they have some ideological leanings, and we see they either interpret the Constitution as originalist or living constitutionalist, revealing 2 different perspectives along single divides. So we see the brief, we will not have to remember any of these justices. You do have to remember that the Chief Justice is John Roberts, one of the conservative Republican appointed justices. Again, of course, not hardline conservative. He's aligned with some liberal interpretations. But we see in our current Supreme Court, Justice Clarence Thomas, the longest serving justice, appointed in 1991 by President George H.W. Bush, is known for his strong originalist views, aligning with the conservative wing, oftentimes referred to as one of the most hardline conservative Supreme Court justices there is. We saw him about 2 years ago in the national spotlight as he was being criticized for, taking trips from wealthy donors, and that brought up a very significant discussion in the political world about the ethical responsibilities of Supreme Court justices, as this was a dimension of their lives that was not heavily scrutinized or regulated. And it was revealed that similar actions were taken by other justices in U.S. history. So we also see Justice Samuel Alito, a staunch conservative. Alito was appointed in 2006 by President George W. Bush. You also see Justice Neil Gorsuch, appointed by President Donald Trump in 2017. Gorsuch is known for his textualist approach to the Constitution. Justice, which is like a originalist with a little bit of living constitutionalist. Justice Brett Kavanaugh. Kavanaugh joined the court in 2018, also appointed by Trump, played a key role in some high-profile cases since. Amy Coney Barrett, Justice Amy Coney Barrett, is the newest Trump appointee. Was appointed by Trump in 2020, cementing a conservative supermajority on the Supreme Court, while we also see Justice Ketanji Brown Jackson, the most recently appointed Supreme Court justice, appointed by President Joe Biden in 2022, the only Supreme Court justice appointed by Joe Biden. She made history as the first Black woman to serve on the Supreme Court in the year 2022. We also see Justice Sonia Sotomayor, appointed by Barack Obama in 2009. Sotomayor was the first Latina woman on the court and is often referred to as often seen as a voice for progressivism. Hard to get that down. And Justice Elena Kagan, another Barack Obama appointee who joined the court in 2010 before becoming a justice. She was the first female Solicitor General of the United States. So we see just a little bit of background of the Supreme Court justices that currently reside within our Supreme Court. We have had 2 presidents in the past that have appointed 8 justices. Roosevelt and Washington, Eisenhower, Lincoln, and Harrison have appointed 4, and then and ever since, you see in recent years Reagan, Nixon, Truman, and Trump, who have each appointed 3. So it's not completely uncommon, although it's I guess as a president, a lucky opportunity to be able to appoint so many Supreme Court justices. Now, which cases reach the Supreme Court? This is an important question to be able to answer. Well, the Chief Justice of the Supreme Court has the absolute power to determine which cases are to be heard by the rest of the body. The Chief Justice currently is John Roberts, and he has made about 80 decisions regarding what cases will reach the Supreme Court in recent years. So remember that the Chief Justice has a little bit of influence and authority over the body, as they have the power to determine which cases are to be heard. Now, what is a landmark ruling? Simply put, landmark rulings are rulings that substantially change the interpretation of existing laws. Think of, well, in the 1970s, actually, won't go into that yet. We'll save these till we go through the next few examples. We're going to examine about 4 Supreme Court landmark rulings, and these oftentimes established a standard or a test to be utilized by lower courts in future rulings. They can be overturned and create new standards or new tests to be relied upon in the future. Nothing specifically special about these rulings outside of how they are interpreted. Their significance is relied on the impact that they have after the ruling has been provided. So let's look at some of these landmark rulings. I pick these because these are the ones that are most familiar to you as citizens, and they cover a wide range of issues that are relevant in American government. So we see the implementation of Roe v. Wade in the 1970s, which addressed reproductive rights. Again, we are not going to be spending too much time going in depth or detail. I am not here to present opinions on either side. What I'm here to do is provide the Supreme Court's founding reliance in their rulings in Roe v. Wade and the eventual overturning landmark ruling in Dobbs v. Jackson, which occurred in 2022. So, in Roe v. Wade 1970s, the U.S. Constitution, they argued, provides a fundamental right to privacy that protects a pregnant woman's liberty to choose whether to have an abortion, relying on the Due Process Clause of the 14th Amendment. So we see the Due Process Clause of the 14th Amendment directly providing this right, according to our justices in the 1970s. Now, there a little research you can do. There is no direct right to privacy within our Constitution, although our Constitution frequently references dimensions of our daily lives that provides privacy to individuals. Some examples consist of the First Amendment addresses right to privacy of beliefs and privacy of group membership. You have your right to affiliate with any group, believe what you want, or say what you want, and that is your privacy. And you also have the right to keep that private. The Third Amendment is your right to privacy of the home. Housing and Quartering Soldiers Amendment. Although it's not relied upon in recent days, that is providing you the right to privacy of your own home. The Fourth Amendment, protection against unreasonable searches, right to be secure in their persons, houses, papers, and effects. You have privacy, right to privacy in your persons from search and seizure of other individuals, your house, your papers, and effects. We see that in recent years regarding your car. Fifth Amendment, right to privacy in personal thoughts and documents, as your right to not to speak against yourself in courts. The Ninth Amendment provides a protection of rights not granted in the Constitution to be left up to the states and the people. This is sometimes referred to as a right to privacy in this sense. And the 14th Amendment says, quote, deprive any person of life, liberty, or property without due process of law, end quote, which was a foundation for providing privacy in that dimension. We also see the Due Process Clause within the 14th Amendment. Again, we will not go into detail on this until later on. And we see that, so the original ruling in Roe v. Wade founded off of the idea that our Constitution provides rights to privacy that expand into an individual's healthcare and daily lives. This provided federal protections of privacy and healthcare. The ruling focused on the protections of liberty under the Due Process Clause. That was the primary dimension, as this is one of the liberties granted to individuals in our daily lives, according to the Supreme Court justices of the 1970s. Now, let's know that this has been overturned. The landmark ruling of Roe v. Wade was overturned in the landmark ruling of Dobbs v. Jackson in 2022. In this ruling, they said, quote, they argued that the Constitution of the United States does not confer a right to privacy directly. They argued that, relying on the Ninth Amendment, that abortion is an issue that is currently left up to the states. As it is not directly addressed in the Constitution, the ruling states that it would be left up to the states. My assumption is that was relying on the Ninth Amendment. So we see that this has been overturned, and I wanted to provide the constitutional founding for the original ruling and the recent overturning of Roe v. Wade without any second of me providing my opinion. Not a second of that was my opinion. I am happy to discuss these issues with you in detail via email, but these are the different perspectives provided by different reasonings provided by the individuals who provided the rulings. And we have another Supreme Court landmark ruling, Lemon v. Kurtzman. This ruling addressed the separation of church and state by providing clear standards. There's a three-part Lemon test that was implemented after this ruling. So after the landmark ruling, as I said before, landmark rulings implement a standard or a test. Under Roe v. Wade, the standard was addressing the issues through a national protected right to privacy, and then through addressing state rights through Dobbs v. Jackson. Now, the test implemented through Lemon v. Kurtzman was referred to as the Lemon test. This is a test utilized to make sure that there is not an excessive intermingling of the church and the state. So it asks three questions. Does the law have a secular purpose? If a law has a secular purpose, it can be considered. Does the law's primary purpose inhibit religion? If it does not inhibit somebody's religion, no matter the religion, it can continue being considered. And third, the government must not be excessively entangled with religion. Is there too much engagement between the church and the state through this legislation? If there is, then we cannot have this legislation be considered. But if there is not excessive entanglement, then we can pass this legislation. Now, the Lemon v. Kurtzman ruling, this was relating to federal funding to private schools. Now, in Rhode Island, this was originally started in Rhode Island, the private schools were significantly Catholic. So private schools were receiving federal funds, but 95% of them were Catholic schools. So this was viewed as excessive entanglement between the church and the state, as the church was funding pretty much exclusively one religious institution to teach, to build up educational institutions. So the Kennedy versus Bremerton school district overturning that landmark ruling was a little different. It wasn't regarding federal funding, but instead it had to do with a football coach, who, after a football game, would go out to the center of the field and kneel and pray. And he did not make the team do this. He simply did this in his own time, but while acting as a representative for the school district. Now, this eventually made it to the Supreme Court, and under the Lemon test, technically he should be prohibited from praying on the middle of the field. But the Supreme Court ruled in 2022 that he had the right to prayer, and the Supreme Court said, quote, "History, tradition determine scope of constitutional rights," end quote. And although this was the originalist collective ruling in this favor, we see them maintaining a living constitutionalist scope when regarding the issue of religion and regulating religion. So you see through this example, for one, the Lemon test, which was a significant test relied upon when determining the excessive entanglement with religion and the state, is no longer present in our federal government, and we have not implemented a new test through a different landmark ruling. Instead, we have overturned the Lemon test and overturned the ruling from Lemon v. Kurtzman through our Kennedy versus Bremerton Supreme Court ruling, as Lemon v. Kurtzman is another Supreme Court landmark ruling that has been overturned. This also shows the difference between, it shows how originalists are not hardline originalists and living constitutionalists aren't hardline living constitutionalists. They both consider the other perspective. An originalist considers the changing threats to society, and the living constitutionalist considers the original intentions written that these rulings were written with, our Constitution was written with. Plessy v. Ferguson. We're going a little back in history for this one, as this ruling was implemented in 1896. Now, Plessy was the name of an individual who was actually 1/8 black and was able to ride the white railway cars peacefully without any conflict. But he knew that this was problematic, and he did not support the Separate Car Act of 1890. So instead, Plessy decided to hop on the white train and notify them that he is indeed 1/8 black. He was then arrested and brought to jail, and they were intending to bring this to the Supreme Court, which they eventually did. They were a lot more hopeful that their ruling would provide the foundation that, well, the Separate Car Act of 1890 was unconstitutional. Instead, this is where we saw a bit of a sad moment in U.S. history, as our Supreme Court ruled that separate is equal. Separate but equal is acceptable. One second. We had we had 8 justices at the time because we had a 9-justice Supreme Court, but we did have one pass away before the ruling. And as long as there isn't a tie in a Supreme Court ruling, then we can have the remaining justices cast their vote. So in this ruling, we saw a 7-to-1 vote in favor of segregation. Segregation can be separate but equal. And out of the 8 justices, we had 1 justice who ruled against it, John Marshall Harlan. This individual stated, quote, "The white race deems itself to be the dominant race in this country," and later referred to the Constitution as colorblind, acknowledging the racial dominance of the time and how our Constitution ignored this reality of life at that time. Fascinating position to have in the 1890s. Segregation was then protected for another 70 years until Brown v. Board of Education overturned the ruling provided in Plessy v. Ferguson. This overturning occurred in 1954 and there was already a significant push for civil rights, but began the legislative push for civil rights legislation that occurred through the early 1960s, late 1950s. And so it is worth noting that when you look at the time between Plessy v. Ferguson up until Brown v. Board of Education was heard by our Supreme Court, there was a 70-year period. And we have only gone 60 years since this ruling was provided in U.S. history. So we have gone less time without segregation than the U.S. had protected segregation by our Supreme Court. A fascinating concept, but the main point here is, remember, we've definitely all heard of Brown v. Board of Education and Plessy v. Ferguson, but remember that Plessy v. Ferguson provided the Supreme Court ruling that separate but equal is acceptable, and Brown v. Board of Education eventually overturned that. So Plessy v. Ferguson was overturned in 1954. Brown v. Board of Education has not been overturned. And another Supreme Court case that we will look into from more recent years. And I consider this one because it's a great pivot into the next topic we cover in these lectures, which is civil rights and civil liberties, and which shows how the battle for civil rights and civil liberties is ongoing for many collectives in this country and throughout the world. So in 2015, we saw a Supreme Court ruling via Obergefell versus Hodges, in which an individual by the last name Obergefell was married, and he was in a marriage with another male individual. The state they lived in, gay marriage was not legal, so they had to go to, I believe it was Maryland, I might be wrong on this, but they had to go to a bordering state to get married, and then they went back home and they lived the rest of their lives in their home state. Sadly, their lives were not that long, as one of them passed away to an illness. On the death certificate, the individual did not have their marriage name. The husband was adamant that they both wanted him to die with the last name Obergefell. And so they brought this case to the Supreme Court. Of course, his husband had long been passed away, but we saw this ruling provide the fundamental right to marriage to all. So he was able to have the correct last name on his death certificate, and our Supreme Court in 2015 relied on the Due Process Clause and the Equal Protection Clause of the 14th Amendment, ruling 5-4 in favor of Obergefell, that the fundamental right to marriage is to be protected on the federal level for all couples, same-sex or not. So we saw this ruling being provided in 2015. This has not been overturned. We see the right to marriage provided through a Supreme Court ruling over any specific legislation. Now, here is another one. this could be to some of you a very hot topic issue. To some, probably might not care much at all. Um, I think this is a great example of the differences between originalist interpretations and living constitutionalist interpretations, and that is the reason for including it in this lecture. So, a very simplified history on the District of Columbia versus Heller, because, well, we don't have too much time to give you the whole background of all of these, but there was a police officer in Washington, D.C., the District of Columbia, who who had a firearm for his on-duty work. Now, we also, for a brief period in Washington, D.C., saw legislation that said if you are not, if you are not a police officer or a trained individual currently working, then you cannot have a firearm in public. So, which was a very unique bit of legislation that's not considered out in Montana in recent years, but this was due to significant gun violence in the inner city of Washington, D.C. I come from that area loosely, as gun violence was significant and looked very different than gun ownership in Montana, simply put. So that was one of their attempts to addressing that it was one of the murder capitals of the 90s in the United States. So they implemented that legislation, but this police officer was adamant that he had a right to own a gun, even especially when he was not on duty, as well as when he was on duty. So he, of course, eventually brought this to the Supreme Court, and when this was heard by our Supreme Court justices, you saw a divide among their perspectives, as there was an originalist arguing that, well, the Constitution provides provides the right to bear arms in a well-regulated militia, and this aligns with that amendment. You have the right to bear arms, and they use that originalist interpretation to protect the individual's right to own the guns, although the regional legislation said otherwise. Now, the living constitutionalists said, well, of course, these are generalizations, but they argued that because of the significant and rising threat of gun violence in Washington, D.C. at the time, this was the best solution possible for the legislature in the state. So they argued that it would be favorable to allow the regulation to occur within this district, and to allow, as we have a shifting threat from what our original founding fathers interpreted. Now, of course, this is all referring to our Second Amendment, which states, it's a little cut off because when I record it's in the bottom right, although I'll fix it for you guys, a well-regulated militia being necessary and to security of a free state, and the right of the people to keep and bear arms shall not be infringed. So, very brief, simple, sweet and short amendment, but it protects your right to bear arms. The ruling that was provided by the originalist collective, as they provided that the police officer has the right to own the gun in that case. Let me see. There are times when I would go through the history of gun legislation in the United States and go through a handful of past rulings that led up to this ruling. But I'm just, for the time, since we're already about at an hour, I'm just going to skip through. The main conclusion of this slide is it relates to private gun ownership, and it provides the divide between originalists and living constitutionalists among our Supreme Court. So what checks do we have on our judicial branch? Well, if you are a part of the executive branch, remember the president, the cabinet, the bureaucracy, the governors, well, you can appoint judges to the Supreme Court, to all federal judge positions, all circuit, district, and supreme. District, circuit, and supreme. In addition to being able to appoint judges, presidents can grant pardons, reprieves, and commutations, so they can overturn the rulings provided within our judicial system through one of these three actions. We also see that the legislative branch has the power to act as a check on the judicial branch. We see that the legislative approves judicial appointments. We've seen this be more so a few years ago, but the scrutiny that they can put on a judicial appointment can really dictate the direction in which those hearings will go and if their nominees will be considered. And it may have an impact on future nominees that are brought forward due to how difficult the process could be. One of the ways that they can exert influence. They also draft the legislation that the courts must interpret. Remember, they interpret the Constitution and statutory law. So if our legislative branch has passed legislation that made it through all 4 steps of the legislative process, then the judicial branch must interpret it and must rely upon it in their rulings. Now, the legislative branch also has the power to determine the number of judges on the Supreme Court, a power that could, if decided, could in a way maybe even be very destructive. They decide we're going to have 50 members of the Supreme Court, or we're going to have a Supreme Court that looks just like the Senate. Now, let me be clear, that will never happen. That is not a possibility. But technically, that power is granted to the legislative body. And we remember the legislative branch does not just impeach presidents. They can also impeach federal judges. So this impeachment power also applies as a check on the judicial branch. Here's everything, all the key takeaways I want you to learn. Now, again, when we went into the specific Supreme Court rulings, a lot of these are focused on just what issue is addressed. I want you to have your individual takeaway about the details and the conclusion of these rulings, but we must all understand what issues are addressed and which ones are our current law of the land, so to speak, our current landmark rulings. Like, it is important to remember that Lemon v. Kurtzman, Roe v. Wade, Plessy v. Ferguson have all been overturned. And Brown v. Board of Education, Obergefell v. Hodges, District of Columbia v. Heller, those have not been overturned. That is an important detail to remember. Here are your answers. I know it's a lot, but I believe in you. Some of this kind of bounces off of the past bullet point and relates to past lectures, or it's regarding an issue that you have addressed many times in your life. Now, what is due this week? Go through your discussions, go through your readings, same old stuff. If you're still having difficulties, email me. I'll get back to you. Remember that I have to let 2 weeks go by before I can grade your discussion posts, so I can just now get to grading your most recent ones. There are a handful that I hadn't graded from the week before, but I'll get to those today or tomorrow. And by the end of this week, all discussion posts, excluding the one you're working on today, this week, will be graded. So make sure you go through and check your grades. I'm providing some detailed comments. I'm going to, there are 7 discussion posts. I am going to gradually be more of a pain for you and grade with more scrutiny up until about discussion post 6. And then the last one, I'll give you a little bit of flexibility. But I'm going to be harsher and harsher with every week, not because I want to lower your grade or critique you or disagree with you. It's because I want you to get something out of these discussions. I'm doing this so you can improve your discussion posts, improve your writing, improve your ability to engage with people who disagree with you. That's the purpose of this. I'm not critiquing you. I am helping you learn how to present yourself to those who may disagree with you on the onset and help them understand you. So, just my take. We have a quiz this week. 14 questions, short answer and multiple choice. Email me if you have any questions. Closed notes. Do not use your notes. Remember, it is obvious if you're Googling questions. And once we get to the later quizzes, I will be really, really getting on you about that. I will not give you points if I think you Googled a quiz on this quiz, but I will give you a 0 on the quiz in the future if you clearly Googled the question. So do not do that. Sorry if that was a bit mean. I apologize. I hate when I rambled on. I was like, this is a 4-step process to pass legislation. I read a question. It's like, oh, that's exactly what Google would say. About 7 steps or whatever. Makes me sad. Also, we have a midterm due next week, the end of next week. I will give you a simple video on Elon Line that I'll post, week 8. That explains how to write a good midterm essay. It's 1 page. It's the beginning of your term paper discussion. You're just going to practice writing an introduction paragraph. Identify the dimensions of the issue that you're going to explore in more detail. And what I'm going to do with this, I'm going to, when it comes to the grade you get, loosely grade it. But when it comes to the comments I make, heavily grade it. I'm going to give you 1,000,000 comments on this midterm. And my hope is that you can take these comments and apply all of them and have a great final paper towards the end. I wanted to have you turn something in and get my thoughts and comments back before you went too far and wrote an entire paper. So just something to get prepared for. And good lecture today. I hope you guys enjoyed this. Again, I wish I was able to talk to you guys in person. Um, but if you want a Zoom call with me, I would love to go in more detail on these. I could make it more fun, more engaging, make it more applicable to your life. Just reach out to me and we'll schedule a Zoom call and we'll go into details and have a little more fun with this content than you probably are just sitting there at home looking at your laptop. I know I'd appreciate it. Um, I'm thinking next week of maybe doing like a 2 hour long window in which I'll have an open Zoom for anybody to come talk to me about anything in the class, kind of like office hours. Although happy to do that anytime, any day. But I will have an open period. So if there's a window of time that works well for you, email me and I'll try and have that be the window in which I have an open Zoom call for everybody. But yeah, thank you guys. Have a good week, and I will see you hopefully via email very soon.